This video is to offer supportable direction for the case advocates. But first, let's question, if this information is not true, why is Edwards not being sued for libel? Let us start by saying, although this video identifies a civil case going back to 2012, the case illegality still cannot be considered legally out of time to be addressed. The case Edwards versus Morneau Shepell was a libel action against Shepell's guidance counselor, Catherine Hayman, citing her unethical conduct. Unable to afford a lawyer, Edwards had to represent himself, and Shepell ultimately won the case, but as now can be said, unethically. And one lawyer tactic stands out as the catalyst for bringing about this entire perversion of justice. From the outset, Morneau Shepell's senior in-house counsel, Roslyn Cogan, obstructed justice by rendering discovery impossible. She did this by refusing to provide Catherine Hayman's professional credentials and contact details, thereby preventing the lawful service of legal documents to be served on Hayman. This obstruction was serious enough in itself, as it severely restricted the information Edwards was able to place before the court. However, after the case concluded, an international private investigation revealed a far more disturbing truth, Shepell's factum, prepared by Roslyn Cogan and advanced by Shepell's court counsel. Pamela Meals of the Toronto law firm Aird and Burles was in fact entirely fabricated. Shepell's factum, the epitome of a scandalous, frivolous, and vexatious pleading, did not even name Catherine Hayman, the very person it claimed to defend. For the record, Hayman did not attend court and had no involvement in the proceedings whatsoever. Crucially, indicative of false representation, there is no record of Hayman supporting, endorsing, or authorizing any of the statements made by Shepell's lawyers on her purported behalf. But we had to believe that Shepell's factum was pertinent to Catherine Hayman because, before allowing the matter to proceed, Justice Thomas Bealby at Ontario's Brampton Court questioned why Hayman was not identified anywhere within Shepell's factum. In defense of what was clearly an improper pleading, Pamela Meals quickly assured Justice Bealby that everything contained in Shepell's factum was pertinent to Catherine Hayman, despite the fact that Hayman was never mentioned at all. Accepting Pamela Meals' word, the judge allowed the case to proceed. However, the fact that Shepell's factum can now be legally identified as entirely fabricated leaves no doubt. The deception advanced by Roslyn Cogan and Pamela Meals was deliberate, not accidental. This conclusion is further reinforced by Shepell's factum substituting the authentic licensing authority and its governing legislation, required by legal code to be disclosed to the court. But making matters legally worse, the substituted authority disclosed to the court was, in fact, unable to be legally quoted regarding Catherine Hayman's ethical standing. As a result, the court was presented with a false regulatory framework that had no legal application to Catherine Hayman's ethical standing. To understand the significance of this authority omission, after the Brampton case was over, the authentic licensing authority pertinent to the case, the Texas State Board, conducted its own ethical inquiry into Catherine Hayman's conduct and found that Hayman, based in Austin, Texas, had failed to uphold the board's ethical standards. This awareness doesn't just identify that Shepell was using a counselor not licensed to practice in Canada. The finding also underscores how effective Pamela Meals' substitution of the governing authority was in influencing the court's judgment in Shepell's favor. Thus, the glaring reality, the court's judgment was rendered without the very authority whose legislation and ethical standards should, by legal necessity, have dictated the outcome. Consequently, the judgment is not merely flawed, it is legally untenable. Yet despite this, it remains in force, continuing to impose court costs and substantial stress on Edwards from a process that should never have been legally sustainable in the first place. But the negligence allegations do not end there. What transforms this injustice into a complete disgrace is the sheer number of legal professionals and officials who over the years have been asked to uphold the law and address this case injustice, yet they have chosen to ignore the significance of doing so. The consequences of this have been devastating. The damages are now substantial, with two families being left profoundly impacted. Meanwhile, the pattern of inaction appears consistent with shielding two lawyers from potential prosecution for criminal obstruction of justice. Before proceeding, it is important to clarify the legitimacy of Edwards' allegations and understand why advocacy mediators should be able to address this matter without legal resistance. Edwards' allegations are not founded on opinion, speculation, or recollection, but on official documentation capable of independent verification. As such, there can be no genuine dispute as to the existence of the evidence. It does exist, and its existence, recognized by applicable law and professional codes of conduct, demands examination. On this point, the governing legal framework is both clear and specific. And this is the argument that supports legal advocacy. Legal code insists this case must be addressed, but occurring in 2012, can it be legally upheld to be out of time? Apparently not. The Supreme Court of Canada's ruling in Pioneer Corp v. Godfrey explicitly confirms that fraudulent concealment can suspend the limitation period entirely, meaning if fraud is involved, the case is not out of time. With Shepell's defense factum actively omitting the on-point governing authority legally required to be disclosed to the court, choosing to instead insert one other authority unable to be legally quoted regarding Catherine Heyman, and lawyer Pamela Meals making false claims directly to the judge about the veracity of Shepell's factum, the circumstances are consistent with the principles of fraudulent concealment recognized by the Supreme Court of Canada. Thus, the Supreme Court precedent prevents the Edwards case from ever being simply dismissed for being out of time. To help advocates get this case addressed, let's just look at some of the legal code violated by the lawyers Roslyn Cogan and Pamela Meals. Please remember at first glance, Shepell's factum appeared detailed, plausible, and professionally constructed, but beneath its appearance of legitimacy, it has since been proven 100% fabricated.
In Chapter 5 of the Rules, Relationship to the Administration of Justice, Section 5.1, in The Lawyer as Advocate. 6. It states, when opposing interests are not represented, for example, in without notice or uncontested matters or in other situations in which the full proof and argument inherent in the adversarial system cannot be achieved, the lawyer must take particular care to be accurate, candid, and comprehensive in presenting the client's case so as to ensure that the tribunal is not misled.
With Shepell lawyers blocking discovery and them fabricating the entire case, accurate, candid, and comprehensive are just a few words that cannot be used to describe Shepell's case.
5.1-2 Commentary. When acting as an advocate, a lawyer shall not a. abuse the process of the tribunal by instituting or prosecuting proceedings which, although legal in themselves, are clearly motivated by malice on the part of the client and are brought solely for the purpose of injuring the other party.
Edwards was a Shepell client whose family was unethically destroyed by the unethical conduct of a Shepell counselor, only for him to then suffer further harm through the unethical actions of Shepell's lawyers. Thus, unethical conduct was used to injure Edwards.
In B, it states, a lawyer shall not knowingly assist or permit the client to do anything that the lawyer considers to be dishonest or dishonorable.
Of course, as this case proves, this rule cannot work when you have two corrupt lawyers both on the same side.
In E, it states, a lawyer shall not knowingly attempt to deceive a tribunal or influence the course of justice by offering false evidence, misstating facts or law, presenting or relying upon a false or deceptive affidavit, suppressing what ought to be disclosed, or otherwise assisting in any fraud, crime, or illegal conduct.
We can safely say, without fear of contradiction, by entirely fabricating its defense, Shepell lawyers did successfully suppress what ought to be disclosed, and they did rely upon a false, deceptive affidavit.
In G it states, a lawyer shall not knowingly assert as true a fact when its truth cannot reasonably be supported by the evidence or as a matter of which notice may be taken by the tribunal.
Fact, the judge did take notice of Shepell's unsupportable statements and relied upon them in reaching his decision. As a result, his decision now stands in direct conflict with the legislation and regulatory standards that legally govern the case.
In I, it states, a lawyer should not deliberately refrain from informing the tribunal of any binding authority that the lawyer considers to be directly on point and that has not been mentioned by an opponent.
Clearly understandable, Edwards at that time could not identify the binding authority because Roslyn Cogan refused to disclose it to him. Apart from that, Pamela Meals went one better and completely substituted the official regulator. Thus, with legal code specifically forbidding this, Pamela Meals' misconduct is confirmed.
Under disclosure of error or omission, it states, As an advocate, a lawyer must act honestly and ensure the court is not misled. If a lawyer discovers they've made an error or omission, they are required to disclose it and take reasonable steps to correct it. In short, a lawyer's duty is both to advocate and to rectify any mistakes, ensuring the integrity of the process.
Roslyn Cogan and Pamela Meals have had 14 years to rectify their mistakes, but have chosen not to. Thus, yet another code violation out of many others is evident.
Under Encouraging Respect for the Administration of Justice 5.6-1 Commentary 1, it states, a lawyer should not hesitate to speak out against an injustice.
In reality, the reaction to this code has been remarkable because 220 Aird and Burles partners were informed of the facts concerning their colleague Pamela Meals' unethical conduct. Yet, their response was they would stand behind the court judgment. But even more troubling given the implications, Justice Bealby, the Brampton case judge, has also refused to address the illegalities he presided over. His refusal to act leaves no room for ambiguity. By remaining silent in the face of the injustice, he not only undermines the integrity of the court and the principles of judicial accountability, but also renders himself complicit in the continuing obstruction of justice. And just on the off chance it slipped everybody's mind, obstruction of justice is a criminal offense.
Under Encouraging Compromise or Settlement 3.2 for a lawyer shall advise and encourage the client to compromise or settle a dispute whenever it is possible to do so on a reasonable basis and shall discourage the client from commencing or continuing useless legal proceedings.
In this instance, a reasonable settlement should have been straightforward based on the fact Shepell never did have a valid defense against Edwards' allegations. Yet rather than act with integrity, as code requires, Shepell lawyers chose to conceal the truth, deceiving the court through fraud. According to the applicable legal code, this willful act of deception by Shepell's lawyers was, and remains, an unlawful abuse of privilege and process that requires to be addressed to put right the wrong. Under the Law Society of Ontario's Rules of Professional Conduct, Section 7.1-2, it defines professional misconduct. In particular, Part E of that section includes conduct that is prejudicial to the administration of justice. In other words, any behavior that undermines the fair administration of justice can be considered misconduct. The Edwards case provides no basis upon which it can reasonably be suggested that Roslyn Cogan and Pamela Meals acted in good faith. The conduct identified throughout these proceedings stands in direct contrast to Rule 2.1 to one of the Rules of Professional Conduct, which states,
a lawyer shall conduct himself or herself in such a way as to maintain the standards of the profession and to uphold the reputation of the legal profession. Integrity is the fundamental quality of any person who seeks to practice as a member of the legal profession.
This rule makes clear integrity is not an optional standard. It is the foundation upon which public confidence in the legal profession depends. By making a farce of the legal code, Roslyn Cogan and Pamela Meals obstructed justice at every turn. If not for their intentional fraud being uncovered by a private investigation, they may well have succeeded and gotten away with falsifying Shepell's case. But this raises a serious issue for the Ontario legal industry. On this occasion, the investigation proved essential. However, the public should not be burdened with having to investigate the veracity of lawyer claims, only to then spend years battling a self-governing profession to uphold the very integrity that profession claims to represent. And this raises a grave question. With little apparent concern from the Ontario Law Society to uphold its rules, just exactly how many cases of lawyer fraud have quietly slipped under the radar over the years, simply because the public trusted legal statements? Due to the prolonged delay in addressing this confirmed injustice, Ontario's Advocacy Centre for the Elderly has now been called upon to intervene, as the matter has escalated into elder abuse. The fact that this intervention is being sought during Seniors Month only serves to highlight the seriousness of the situation. For 14 years, Edwards has sought to have this case illegality addressed. Yet, despite his excessive efforts, every avenue of accountability has failed to produce a remedy, leaving him to confront a system that has repeatedly frustrated attempts to hold the lawyers involved accountable, in line with law and legal code. Beyond the legal complexities, this is also the story of a man, now elderly, who was nearly killed on 2 separate occasions as a result of Catherine Hayman's defamatory direction against him. His family and life have been altered beyond recognition, and the consequences have been profound and enduring. Morally, there can be little question that all of this harm arose from conduct that should never have been defended, concealed, or permitted to continue. Addressing this injustice is not only about rules, it's about restoring dignity to a person who has waited far too long for law to be upheld. With Edward's civil rights violated long ago, up against legal privilege, this case highlights the systemic discrimination that self-represented litigants can encounter within the Ontario court system. Disadvantaged by that imbalance, the system didn't just fail Edwards, it has repeatedly operated to his detriment, denying fair treatment to which every litigant is entitled. And such discrimination is wholly unacceptable in a justice system founded upon the principle of equality before the law. And indisputable, Ontario's legal industry has no defense to actively denying people their legal rights. This video has been produced with a view to assist advocates promoting a legal resolve for this most egregious injustice. And why is this a moral and honorable stand? Because there is no excuse for unethical behavior being allowed to obstruct justice. Ontario lawyers with integrity, you're asked to stand with advocates, to restore accountability, to challenge wrongdoing, and to help bring about justice the public can respect.